To know the law. I'm absolutely thrilled to have you here today for this explainer, because we are going to unpack a really fascinating piece of state-level civil rights legislation, Georgia Senate Bill 375. Now look, legal documents can often feel like a total maze of jargon and endless cross-references, right? But our goal today is to give you a clear, plain language breakdown of exactly what this proposed bill does. We're going to dissect the text piece by piece so you can see exactly how a single legal definition can actually ripple through an entire state government. Okay, let's dive into this. First, we'll cover the introduction to SB 375. Second, we're defining Hinduphobia in law. Third, we'll look at who this protects. Fourth, we'll check out the First Amendment guardrails. And finally, we'll wrap up with the all or nothing clause. All right, starting right off with Section 1, Introduction to SB 375 and amending Title 50. So, right at the very top of the bill, it explicitly states its intention to amend Chapter 1 of Title 50 of the Official Code of Georgia Annotated. Now, if you're not familiar, Title 50 is basically the ultimate rule book for general state government provisions in Georgia. By slipping this amendment in right here, the bill's main goal is to integrate a specific brand new definition into how the whole state government handles anti-discrimination laws and criminal penalties. Essentially, it's giving the state government a brand new vocabulary word that they are legally required to recognize and use. And that brings us to Section 2, defining Hinduphobia in law, which is really the core subject here. Let's look at the exact wording. Section 1, Paragraph A, line 20 defines Hinduphobia as, quote, a set of antagonistic, destructive, and derogatory attitudes and behaviors towards Hinduism. Let's just put that into plain layman's terms for a second. This legislation is explicitly targeting negative actions and hostile mindsets directed at the religion of Hinduism. It's setting up a legal framework that actually recognizes that very specific prejudice. So it gives the state a totally concrete way to identify when someone is acting with destructive or derogatory intent toward this specific religious group. So the crucial point is, how does this actually get applied? Let's hit Section 3. Who does this protect? Agencies and fact finders. Because having a new definition is great, but words on a page don't really do much unless somebody is actually required to use them. So who does this bill apply to in the real world? Who actually has to enforce this, and ultimately who gets protected? Well, it turns out the bill casts a really massive net. Paragraph A defines the term agency super broadly. We're talking about all state agencies, authorities, boards, bureaus, commissions, and literally all local political subdivisions of the state. That means everyone from, say, a giant state housing department all the way down to your local city council is bound by this language when they enforce anti-discrimination laws. On top of that, it applies to fact finders in the judicial system, which means judges or juries deciding criminal cases. Ultimately, this protects individuals practicing Hinduism by making sure all these different tiers of government are legally bound to recognize this specific type of prejudice. And this brilliantly illustrates the two-pronged approach of the bill. First, for non-criminal enforcement, any agency that's already enforcing civil laws against religious discrimination must now factor in this definition of Hinduphobia. Second, for criminal enforcement, if a judge or jury is trying to figure out whether to apply an enhanced penalty under Georgia's hate crime statute, they have to consider this definition to see if a victim, or even property, was intentionally selected because of Hinduphobia. So it's both a civil shield and a criminal penalty enhancer. Now, anytime the government defines an attitude or behavior, constitutional questions immediately pop up, right? So let's move to Section 4, First Amendment and guardrails. To prevent any kind of legal overreach, the authors actually baked in some very specific boundaries. It literally says, nothing in this code section shall be construed to diminish or infringe upon any right protected under the First Amendment to the United States Constitution or the Georgia Constitution. Basically, the legislation is explicitly acknowledging that yes, it's defining a discriminatory behavior, but absolutely no way can it be used to override foundational free speech protections. And the bill gets way more specific about what kind of speech is protected too. It explicitly shields your right as a citizen to engage in legally protected conduct, especially expressive activity regarding United States foreign policy or international affairs. This is such a crucial distinction. It means that criticizing a foreign government or debating international relations cannot legally be conflated with Hinduphobia under this law. The bill draws a very hard line, protecting a religious group from discrimination on one side and protecting a citizen's right to freely debate global politics on the other. Plus, there's a big procedural guardrail here. The bill clarifies that this new definition doesn't create any new causes of actions. In plain English, that means this doesn't suddenly give citizens new rights to file civil lawsuits against the state, and it doesn't lower the bar for the evidence you need to prove actionable discrimination. It's really just equipping the state with a new definition to use inside of its existing processes, rather than creating a whole new avenue for people to sue. Finally, let's shift gears to Section 5, the all or nothing clause, or what lawyers call non-severability. Now, what's really interesting about this is how completely rigid it is. Usually laws have a severability clause. That means if a judge strikes down one unconstitutional part of a law, the rest of the law survives just fine. Well, this bill does the exact opposite. It explicitly states that if any single section, phrase, or literally even a single word of this act is declared unconstitutional, the remaining parts are automatically repealed. It is 100% a legal house of cards. If one single piece falls, the whole shebang is voided. The lawmakers even put it in the text that they wouldn't have passed the law at all if they knew a portion of it would get struck down. It's entirely an all or nothing proposition. Let's see how this builds toward actual enactment. If this passes the legislature, the final administrative steps are pretty straightforward. Step 1, it becomes effective the second the governor approves it, or if it becomes law without a signature. Step 2, any existing laws that conflict with this new act are instantly repealed. And Step 3, the new definition gets officially copy-pasted, so to speak, into the Georgia State Code. So what does this all mean? When we look at SB 375, we are watching a state legislature use its power to define very specific words and weave them directly into everyday civil and criminal enforcement. How will defining these specific attitudes in state law ultimately shape the future of our justice system? Are other states going to follow suit and adopt similar definitions? Understanding the exact mechanics of these bills, from the definitions to the strict guardrails, is exactly what empowers us to be informed participants in our civic process. Thanks so much for joining me on this explainer. Keep questioning, keep learning, and as always, know the law.